One Finance and MoneyControl present Personal Finance Unlocked. Download the One Finance app. Investments in the securities market are subject to market risks. Read all the related documents carefully before investing.
So my name is Deepak Jain. I represent an organization called American Academy of Financial Management. It's an organization into financial trainings. I'm also co-founder of an organization called Next Gen Estate Planning Solutions, where we give estate planning solutions through financial advisors. Okay, so to understand the concept of estate planning, you need to understand what is your estate. So the definition says anything you own today is your estate. Everything which you will own on your date of death is also your estate, and everything which you will own post your death is also your estate. Estate planning is a systematic plan to distribute your estate according to your wishes and your what you require out of this estate post your death. And it is not only about death, it is also about incapacitation planning. So if you are unable to take care of your assets due to any reason, death or incapacitation, how do you plan these assets to be distributed or controlled in such a situation? That is called estate plan. Why do individuals require estate planning? Why do families require estate planning? Now, you require estate planning because you want to distribute your assets as per your wishes and desires. You also want to do estate planning because you don't want succession laws to come into place if you die without telling your wishes to the world. These succession laws in India, they are religion based, and different religions are governed by different succession laws, and they cause complications. So if you are a Hindu, your estate is distributed in case you don't tell your wishes and your desires through the Hindu Succession Act 1956. If you are a Muslim, through Muslim Succession Act 1937. If you are a Christian, through Indian Succession Act 1925. And if you live in Goa, it is not distributed as per the Indian Act. It is distributed as per the Portuguese Family Act, which we have codified as a Goan Civil Code. Now, these acts cause complication. I'll just give you an example of a complication. Suppose a Hindu marries a Christian. What law would be applicable on the children? And before you answer this question or think about the answer of this question, remember two things. One, India is a secular country. And second, there is gender equality in India. Both mother and father are equal in front of law. But the law would have to answer this question. And their answer would be based on several facts. One could be, how did these two people get married? Through Hindu rituals or Christian rituals? How are the children being raised? Have they named them Ram or Sham or John or Abraham? Was the child baptized or was a Janeu ceremony done for the child? Does the child usually go to the temple or the church? And based on all of these, they will decide whether the child is a Hindu or a Christian. But what child would inherit would be significantly different in both the religions. And this complication would not have arisen if his father or parents would have created an estate plan. So by not creating an estate plan, you are creating complications. And also, you should do estate planning because you don't want people to fight over your assets or your assets becoming the source of discontent amongst your inheritors. Because of these reasons, estate planning is very, very essential for everybody. So there are 4 key documents which are required by nearly everyone. First is a will. Now, what is a will? Will is the legal declaration of the intention of a testator with respect to his property which he desires to carry out after his death. So when you legally declare how your property is to be distributed post your death, the document containing that legal intention of yours is called will. Now, wills need not necessarily be type stamped or registered. Making a will is a most important thing a person can do. Second document which we all require or people require is something called a letter of guardianship. So many of us have minor children and in case both the parents pass away, the custody of the child would be decided by the court. For third document, also I'll give you a situation. Suppose you are incapacitated, you are in coma, you are paralytic, you are mentally unsound. Under such situations, who would be able to operate your singly operated bank accounts, your singly held mutual fund folios? If you have rented out a property, who would be able to take rent on your behalf? Who would be able to renew this rent agreement? What have you done for that? And what can you do for that? For such a situation, we create a document which is called Springing Durable Financial Power of Attorney. It's a special kind of power attorney which only becomes alive or effective in case you are incapacitated. For the last document, also I'll give you a situation. Suppose you are on a ventilator for more than 15 days and doctors keep you artificially alive. Now, what's the risk? There are two risks involved in this. First, you are in a lot of pain. Have you seen a terminally ill patient? Where all do they put the tubes? Even looking at that person makes me feel the pain. Just think about the person who's undergoing that. Also, the second risk is your wealth would slowly go to a doctor, nursing home, or a hospital. Can you do something about it? Yes. In March 2019, Supreme Court in a landmark judgment said, right to die with dignity is the fundamental right of every Indian. And you can enforce this right of yours by creating a document which is called Living Will or Advanced Healthcare Power of Attorney. It's a special document which tells the world your wishes of end of life treatment. So you can say in this document that suppose I am on a ventilator for more than 10 days, I have less than 5% chance of reviving. So please switch off the ventilator and keep giving me painkillers. I refuse to rot on a bed. That's a legally enforceable right today in India. And that right can be enforced by a living will. Now, I've mentioned four documents to you: a will, a letter of guardianship, a financial durable springing power attorney for incapacitation, and a living will. So, when it comes to minor children, first let us define the age of minority. Now, most people think that age of minority is 18 years, which is true for most individuals. But when a guardian is appointed over a child, the age of minority of that child changes from 18 to 21. So a person becomes major either at 18 or 21, depending on whether his parents are alive or not alive. Now, let's talk about can you do estate planning for a minor children. The first document I have already told you, create a letter of guardianship, because most parents think that in case we both pass away, the custody of our child will be given to the either the grandparents or the maternal grandparents, my brother, her brother, my sister, her sister, which is not true. Because as per the Indian Guardianship and Maintenance Act, there are only three types of guardian. First is called the natural guardian, and only parents can be natural guardian to a child. In absence of parents, society becomes the guardian of the child, and society is represented by the district judge. For us, incapacity planning is when you are unable to take financial decisions. You are in coma, you are paralytic, you are mentally unsound. Under such situations, you would not be able to take financial decisions. And because you are unable to take financial decisions, somebody has to step into your shoes and do whatever you can do. For this, we have two options. The first option I have already told, it's a springing durable financial power of attorney which you create. The second thing which you can, second way you can overcome incapacitation is you can create a, a private family trust where incapacitation is also put as a condition. So you can allow somebody to step into your shoes as a trustee or replace you as a trustee in case you are incapacitated. And whatever you allow this trustee to do for your and your family's benefit, in the trustee they'll be able to perform those things uh, as per the directions given in the trust. As per the law, nominee is not the owner of the funds post the death of the account holder. Nominee is just the caretaker or the distributor of the funds. For example, suppose I have a fixed deposit of 10 lakh rupees, which is in my name, and my wife is the nominee in this fixed deposit. Post my death, the bank will give this 10 lakh rupees to my wife because she is the nominee. But it will give her not to own, but to distribute, and that is the law. And she will have two options to distribute. First option is, if I die without a will, then she'll have to give this money equally or as per the Succession Act. So suppose I am a Hindu. So and I have a mother and two sons alive along with her. So that means she'll have to give it equally to these four people. The second product where nominee becomes the owner is the Public Provident Fund, PPF. In PPF also, the nominee named by you becomes the owner of the funds, not the caretaker. Apart from these two products, all other products in India, whether those are bank accounts, they are fixed deposits, they are mutual fund holding, they are demat accounts, society flats, nominee is just the caretaker, your representative to distribute. That's it. Every property has two parts to it. One is called title of the property, and second is called the control of the property. Now, suppose I ask you, you can have either of them, either title without control or control without title. What will you choose out of these two? Title or control? What do you enjoy? Title or control? Obviously, control. Trusts allow you to control properties without having title to them, because title is risky. Because something is titled in your name, your risk passes to that property. So in a trust, I title the property to the trust and control it as a trustee and maybe a future beneficiary. By doing so, the most important thing it achieves is my personal risks are not transferred to the property. If there's no transfer of asset, most probably estate tax would not be applicable. So, in all ways, private family trusts are a higher form of estate planning, and it is something which every family should look at. So, traditional estate planning said that my job as a estate owner is to give asset to the correct person, and my job ends by giving it to the correct person. I have to just ensure it goes to the right person after me. Holistic estate planning is no. My job does not end by just giving estate to the correct person. My job also involves what will happen to these assets post it is transferred to the person whom I give it to. Because there's a fact, and what's the fact? 70% of a family's wealth is destroyed by the first generation, and 90% of it is destroyed by the subsequent generation. And it's a global fact. So if you ask me, estate planning is 90% emotions, only 10% technicals. Unless you are able to manage emotions in estate planning, you would not be able to create a good estate plan. I'll just give you some instances where emotions may go wrong. Now, if I ask most people how would they like to distribute their wealth amongst their children, most of them come to me and say equally. I would like to distribute it equally after both of us parents have passed away. Now, my question to these parents is, Is equal fair? Equal is the most non-controversial way of division of wealth. It is the most easiest way to think equal. But is it fair? I have found in most cases equal is not fair. I'll give you one or two instances where equal might not be fair. You had two children. One of them went on to become a doctor. And to make him a doctor, you had to spend 2 crore rupees on the education. The second one was smart. He became a chartered accountant. You hardly spend 5 lakh rupees on his or her education. After your death, you give it equally to both of them. Are you fair? And if your answer is no, I should give more to the child whose education I spent less, try explaining it to the doctor's son or doctor daughter. So estate planning is not a very significantly done thing in India. People do tend to ignore it. I would say hardly 1% Indians would have a will, right? Other three documents, even less. Hardly any other people have it. But it is something which is very much required, and the biggest reason why people fail to do it because we are afraid of death, and we don't want to plan our death. Most of us leave it as a ugly thing for our children to sort out. We don't make our death beautiful. We don't plan it. And as wealth managers, as financial planners, it is our duty to sensitize our clients on estate planning, inheritance planning, succession planning, business succession planning. And one finance, when it helps clients and advisors deliver that sort of advice, is playing a significant role by educating people on the importance of estate planning and comprehensive financial planning and wealth management. It cannot be comprehensive if you don't do estate planning.
One Finance and Money Control present Personal Finance Unlocked. Download the One Finance app. Investments in the securities market are subject to market risks. Read all the related documents carefully before investing.